G'day troops, my name is Maro Barsi. I'm a little new around here. It's lovely to meet you, and what we'll be doing through these sessions is going through a case, talking a little bit about what's new, what's interesting, and what we learn as employment practitioners. Today's case is the Chief of the New Zealand Defence Force and Williams, and this is an availability case. An availability case is a case about a clause in a contract which says you need to be able to come and do some work after hours and help us out, and for that, in principle, we've got some extra cash for you. In this particular decision, or in this particular case, Mr. Williams is an employee of the Defence Force. He's a regional technical manager, and there is a debate about his availability for after-hours call work. Long story short, the Defence Force is of the view that they pay him a sum of money, and that amount of money covers him being available to come in and help out after what you might describe as the ordinary working week. As you can imagine, Mr. Williams has a slightly different view, and a court case ensues. What we learn from this case is that the courts have a very strict approach to this kind of clause. Effectively, Mr. Williams says, hey look, love you like a brother, Mr. Employer. I'm absolutely in your corner. Couldn't imagine a happier place to be. But, you know, I'm meant to be available and do some of these bits and pieces after hours. You kind of need to throw a little bit of love my way. To which the employer replies, look, love you like a brother. It's fantastic having you here. Couldn't be a bigger fan. But you realise that we kind of pay you well enough to cover this. You're pretty much looked after. That's how we roll. When the court looks at this, taking a few factors into account, basically says, look, you've given the bloke a vehicle for after-hours use because apparently he is meant to be on call. The employment agreement doesn't necessarily appear to have any wording or language that says, hey, here's a sum of money specifically dedicated for being on call or being available. And 3, the conversations you've had and some of the documentation you've got tends to suggest that the employee doesn't really have much of a choice in terms of whether they're available or not. And what we know from the courts is that in the event you are in this space and you have the capacity to say no, that means you don't need an availability clause. But if you're in that space and you don't have the capacity to say no, you are required to turn up and do the work, then that's definitely an availability conversation. And there absolutely needs to be some provision for that in the remuneration space. Folks, ladies and gentlemen, boys and girls, that's the case in a nutshell. That's the conversation. Availability, if you want people and you want them to have to be available, you have to pay for the privilege. There are some tricks around how you can do that, and we can obviously help you out with that. But as per usual, that's pretty much the end of today's session. It's been a real pleasure bringing it to you. Thanks very much for the opportunity, and we'll see you again sometime soon. Cheers.